Can I change my name? How do I go about changing my name? What court do I go to do that? What's the process? Are there any limitations? Those are the questions we're going to talk about today. I'm Michael Miller. I'm a partner at Cole Miller PLLC, located in Vienna, Virginia. We're a family law firm serving primarily in the Northern Virginia area. I analyze challenges and I find affordable solutions for families and their family law needs. Now, with regard to the name change, there is a separate discussion we're going to have next with regard to children. So in this instant, or for this episode, we're going to focus solely on the adult name change. And this comes up most frequently in our practice in changing names incident to divorce. And in fact, there's a particular statute that provides for that. It's at Virginia Code 20-121.4. And it says, upon decreeing a divorce from the bond of matrimony, the court shall, on motion of a party who changed his or her name by reason of the marriage, restore such party's former name or maiden name by separate order meeting the requirements of Virginia Code 8.01-217. So the way this usually comes up is if we're representing the wife, who is usually the party who changes their name, and they know they want to do that up front, we can put that additional request in the complaint for divorce. However, if it is not, or if we file on behalf of the husband and the wife wants to change her name, it's not the end of the world. We can go ahead and add that provision into the final order of divorce. I've not seen a judge reject the name change in the final order because it wasn't asked for earlier. If that is a problem, you can submit like a real quick one-page motion to change a name and satisfy the requirement that there is a prayer, a request for relief before the court for that reason. Then the final order of divorce would have the order that the name be changed. The benefit here is it's a lot more streamlined process. You don't have to have a separate hearing. You don't have to have separate petitions. You do still have to pay an additional name change fee that is required for these name changes. But other than the additional provision that sometimes will hold up submitting a final order of divorce is if the name change is in there, the courts almost always want to have the person's signature on that document so that the court can be satisfied that the person is aware that their name is being changed. Under other circumstances, the final order of divorce can be signed by counsel, but in this instance, even if everything is proper, they'll still want to see that additional signature so that the person is aware that their name's being changed. So as I said, special statute that provides for that is a streamlined process, fairly common, not a problem. Now, that statute, as I said, cites the requirements of Virginia Code 8.01-217, which is the statute that provides for name change for persons who aren't involved in a divorce. It can also, the name change in the context of a divorce, we may still go to this statute because the name change under the Title 20 is upon decreeing a divorce. I've had several cases where the spouses are coming due for renewal of their passports, and so they don't want to renew the passport with their current legal name and then a few months later have a name change and then have to go through this process again. So what we'll do is just go ahead and follow this process and not do the name change as an incident to divorce. The other thing that's interesting that has come up recently is we worked with a number of families who have moved to the United States, and one of the reasons they want to change their name is because on their immigration papers they did not provide a first name, and so their first name is listed as FNU, which I believe stands for first name unknown. And so you have all these people, FNU, and then whatever name is in their papers. And now that they're here with their spouses or they're married or, whatever the case may be, they want to change their name. And so this is the process we follow for that as well. So any person who desires to change their name or the name of their child, which we'll talk about the particulars of the child in the next session. But, for this one, this is how the adults do it. You have to go to the circuit court So as we talked about in our court video, in this instance, the circuit court is the court with authority to do this. You go to either the county or the city where you reside. However, if you don't have an established residence in a county or city with a circuit court, then you would go to the place of abode that you could show would have good cause exist for you to be there. There is a sole separate provision for incarcerated persons. We're not going to address that because it's not really pertinent to family law. And I said the child matters we'll talk about next. The process works in that you draft a petition, and paragraph B of the statute lays out exactly what has to be in the petition or the application. You will list your place of residence, the names of both your parents, including the maiden name of your mother, the date and place of birth of the applicant's felony conviction record, if any. Normally what we do is put in a provision that says, no criminal convictions. You also have to disclose whether you are a person for whom registration with the Sex Offender and Crimes Against Minors Registry is required. Again, we say, no registry required. And whether the applicant is presently incarcerated or a probationer of any court. Again, we say not incarcerated, not a probationer. So that goes in the, there's an additional paragraph that says that you have to disclose whether you've previously changed your name. So that goes in the petition or the application. It has to be under oath. That goes to the court. That's the process that you can bypass when you do this incident to divorce. Along with the application, you then also turn in the court and turn in an order for the judge to sign off on. And frequently that's for adults anyways, provided there's no criminal history or anything like that. You turn the petition, you turn in the order, and then a couple weeks later you get a call from the clerk's office that the order's been entered. And basically the court order says, upon petition of the petitioner to change their name, the court finds good cause, petitioner's name is changed from person A to person B, and it's entered and so forth. There are some limitations there. If a person is, incarcerated, it is subject to the registration and things like that. And in fact, the provision goes on to specifically say that these limitations on name change would cause any order of name change to be void ab initio, which means it was never valid in the first place. It's void from the very outset. And the statute does also authorize the attorney an attorney for the Commonwealth to file an application to recognize that and have it declared void. So also with that, once the order is entered, then the order has to contain no information other than the applicant's former name or names, the new name, and the current address. There are some old forms out there where all this biographical information that was in the application gets carried over into the order. Under the new or under the current statute, is none of that identifying information goes in the order. And then what happens is when the order is entered, it goes down and the clerk puts it in the court's records, and it gets published that way. However, if you have good cause to show why your name change should not be put in the public record because of risk to your safety, health, or welfare, you can petition the chief judge of the circuit court to waive those requirements. And so I've handled a couple of those that are kind of protective order related, where a spouse wanted to change their name, and we had to add the additional provision as to why the name change should not be put in the record and the safety and risk to the spouse's health. So that's the kind of limitations there and the confidentiality that's involved. Pretty straightforward. If you do want to change your name, most of the time you can go down. There's forms already prepared either through the court's website, or if your court has a law library, they may have forms all ready to go. Again, fill out the application, pay your filing fees, submit an order that conforms with the statute. Again, it's one of those things, just look down through the statute and look what the requirements are, and for the most part, not a problem. So that's the adult name change, and in our next section, we'll talk about the child name change.